Good morning. This is a Bills Committee on Deposit Protection Scheme Amendment Bill 2015. We proceed with the election of a chairman. Nomination, please. Mr. Christopher Zhang. Mr. Nang Seng nominates Mr. Christopher Zhang. Mr. Christopher Zhang, do you accept? Yes. Any other nomination? If not, then Mr. Christopher Zhang is returned chairman of the Bills Committee on Deposit Protection Scheme Amendment Bill 2015. Thank you. Thank you, members, for your support. Well, let's see if we need to elect the deputy chairman. If not, then we can move on to the next item. Let me first introduce representatives from the administration attending the meeting. We have Ms. Selina Yan, Deputy Secretary, Financial Services, and Mr. Jackie Liu, Principal Assistant Secretary, and Ms. Tana Zhang, Assistant Secretary from the FSTB, and from the Hong Kong Monetary Authority, Ms. Meena Dadwani, and Ms. Tess Leung, Head of the Deposit Protection Scheme, and from the Department of Justice, Ms. Bonita Wong, Government Counsel. Thank you. So, may I invite the administration to brief us on the bill, please? Thank you, Chairman. Well, this is the Bills Committee on the Deposit Protection Scheme Amendment Bill 2015. The objective of the bill is to introduce a gross payout approach in substitute of the net payout approach and other improvement measures. And we've prepared a PowerPoint presentation to walk members through the philosophy of the bill and the specific details. So I will invite Mr. Liu to make the presentation. Thank you, Chairman, members. Some background information relating to this bill. The Deposit Protection Scheme was formally implemented in full in 2006, and it was fully implemented by the Hong Kong Deposit Protection Board, Hong Kong DPB, in 2006. And currently, we have a compensation limit of 500,000 Hong Kong dollars per depositor per bank, and all licensed banks are members of the DPS unless they are given the exemption. And deposits denominated in Hong Kong dollars and other currencies are protected. At present, we have a DPS fund size of around 2.8 billion Hong Kong dollars, all coming from the annual contributions from banks. And very fortunately, since its implementation in 2006, the DPS has never been triggered. Nevertheless, the board has done a lot in terms of public education and publicity so as to facilitate the safe and expeditious enforcement. And in the past few years, we have also reviewed the Deposit Protection Scheme. We believe that there is room to further improve the role of the DPS and its operation. Now, major markets around the world have a deposit protection schemes as it is a safety net in the banking system. And we note that after 2008-09, after the financial crisis, there have been major reforms in major markets to strengthen protection regimes, because in their markets, some banks had collapsed, and therefore It demonstrated the importance of deposit protection schemes, and the direction of reform was to make prompter payouts and strengthen the regimes to give greater confidence to the public. And we also observed that in relation to the set-off requirement under the ordinance, if we are to trigger the payout because of the existing set-off requirement, it will serve as an impediment to shortening the payout time frame. So we're going to propose legislative amendments to enhance the payout framework. In short, we're going to adopt the gross payout approach in the compensation determination process. So when the DPS is triggered, according to the existing requirements, there should be a setting off of liabilities owed by a depositor to the relevant bank in determination compensation. That is a net payout. So, for example, if a depositor has $500,000 deposit with a bank and also $800,000 worth of liabilities owed to the bank, then once the DPS is triggered, the depositor will not be given any compensation because the $800,000 liabilities has exceeded the deposit that he has with the bank, and it will be set off. And we have compared ourselves with other major financial markets. There are two major shortcomings. Now, because of the setting off requirement, the Hong Kong DPB will need to get information in relation to deposits and liabilities of the depositor, which takes a long time. And according to the existing mechanism, our estimate is that compensation will only be disbursed to the depositor after 6 weeks. It's a long process, and if compensation isn't made out until 6 weeks later, then in the event of a bank crisis or the winding up of a bank, it will cause a panic. It will also affect the Hong Kong Deposit Protection Scheme status as a safety net in a banking system. So we considered the recommendations of the IMF and also the recommendations of the Financial Stability Board. We propose to introduce legislative amendments such that we will switch from a net to gross basis. That is, the protected amount will not be set off against liabilities owed to the same bank, subject to a cap of $500,000. So taking the previous example, if the depositor has $500,000 deposited with a bank and $800,000 owed to the bank, then when the bank collapses, the $500,000 will be compensated to the depositor first. And yet the depositor will still be required to repay the $800,000 owed to the bank. It will not affect the liabilities owed by a depositor to the relevant bank. So introducing the gross payout approach would help shorten the payout time frame to 7 days, which will be much shorter than the estimated 6 weeks. And under the existing mechanism, after the compensation made, the Hong Kong DPB will recover from the bank's assets for the amount of the compensation paid out. And this amendment will not affect the current creditor hierarchy in insolvency regime. And if the depositors still have liabilities owed to the bank, then the depositors are still required to pay the outstanding debt to the bank, and the level of premium rates applicable to banks will remain unchanged. But once the bill is passed, then the Hong Kong DPB will calculate contributions payable by banks on a gross basis with reference to protected deposits. And this is the major amendments of today's bill. And we would also like to take the opportunity to fine-tune two requirements. We believe that they can be enhanced. The first one is to enhance uncertainty for determination of the quantification date. There is one important reference date, which is the quantification date, QD. It is a reference date for compensation determination, including interest and conversion of other currencies. Under the existing ordinance, the QD is pegged to the Court of First Instance, making a winding up order in respect of the bank, and yet there is some uncertainty in this regard. So we propose to define QD as date of the specified events vis-à-vis the earlier of the following. The two events referred to the CFI making a winding up order in respect of a bank, or the monitoring authority serving on Hong Kong DPB a notice of this decision that DPS should be triggered. The earlier of these two dates will be defined as the QD. It will be the reference date for compensation determination. We believe that this will provide greater clarity and certainty for triggering DPS and will help speed up payouts. Finally, we also like to improve the existing mechanism so that if necessary, the Hong Kong DPB can notify the depositors through electronic means. So upon triggering of the DPS, the Hong Kong DPB will at present notify depositors of compensation entitlements by conventional paper form communications. And with the advent of technology, we consider that the Hong Kong DPB should be empowered to, other than sending paper form notices, send electronic notices to depositors, as this will accelerate the notification process, which will help salvage public confidence. And we also understand that some depositors do not use e-banking or do not receive electronic communication from banks. So we're not going to invalidate paper form notices. We're just adding electronic notices on top of paper form communication. For depositors who are not used to receiving electronic communication from banks, they will continue to receive conventional paper notices as per the present arrangement, so that they will also be notified of the details of compensation. So these are the major amendments in the bill. And you also have the blue bill with you, and basically it's a short one. It has only 11 clauses. Clause 3 amends Section 25 to revise the definition of quantification date, as I explained. Clause 4 amends Section 27 so that in determining the amount of compensation, liabilities owed by depositors to the failed scheme member are not taken into account. Clause 5 amends Section 32 to enable Hong Kong DPB to issue electronic notices to affected depositors, and Clause 8 adds new Section 38 1A, B, and C to provide for the amount recoverable by Hong Kong DPB from or out of the assets of the bank under the gross payout approach. Thank you for your presentation, Mr. Liu. We still have much time left, so I will allow 5 minutes for the first round. Any questions?
Mr. Ng Liang Sing. The legislation is being amended, and it's evolving to protect the depositor. Now, just a declaration of interest. I'm from the banking industry, and the deposit protection scheme had been in place for a period of time, and this is one of the safeguards for stability of the Hong Kong community, because there are workers who basically deposit their life savings in the banks, and of course the banks will have to provide some kind of safety for them, otherwise, so as to maintain stability in community. As for the proposed amendment, well, I've been asked by my colleague just now why there are those who would take out a loan from the bank and at the same time have deposits at the bank, and later on, instead of paying out from the deposits, at the point of payment from the deposit protection scheme, to be paid the protection first. That is, a question is, why not pay up the loan first if there is money in the depositing account, where there is a maximum of $500,000, that being the protection amount, and we hear that this is internationally practiced. If as an international financial hub, we should have a protection to the depositors. So I would support a reasonable cap, and also a payment instead of a netting of the liabilities, provide the deposit payment first. Now, this is not the bank's money. It is the depositor's money at the bank. The bank, well, I have to, on behalf of the bank, say the following. The money of the bank is from the depositors, and from the right hand of the bank, which receives the funds, it loans out the money with the bank's left hand to customers. So if there is any problems occurring, the bank will have to safeguard the depositors who have deposited the money into the bank, and the bank which on-lends to other customers. So this is a very crucial relationship that we have to understand. Within a permissible amount, it is acceptable. And the bank, yes, it will have more pressure, more burden, but in terms of protection, it will achieve security within the community. So I am in support of this amendment. It is acceptable. And later on, I would like to have the government explain the consultation with the banking sector, whether they have heard any views. I think it would be appropriate for the administration to tell us that, what they have heard from the banking sector. As for paragraph 6 in the paper, which you have mentioned just now, well, you did not go into the details of it, but it was mentioned concerning the level of protection. That may change because the contribution or the calculation would have changed. So the premium rates, the premium rates of the banks and the contribution from the banks, because of this gross payout approach, the rates would have increased for the banks. But the increase would not be significant, it says in your paper there. And yes, with the simplification of this approach brought by the gross payment approach, there are savings on the part of the bank, including procedural expenses. So these are the questions I would like addressed. Yes, Mr. Ho. No, there's no answer. Yes, because my time's up. Maybe the next round. Well, because we have time, perhaps we can listen to the answers from the administration first. Yes, thank you, Mr. Chair. Thank you, Mr. Ng, for the questions and also the support in principle. There are 3 points I would like to mention. First of all, why there are depositors who will have loans from the banks, but we will pay them out first nevertheless. First of all, in terms of stability of the banks, yes, we have done other work, for example, Basel III, which requires the banks will have certain level of stability so that there will not be any crisis as such. However, if indeed it should happen, that is, financial crisis or banking crisis, then this will be something very serious to the ordinary citizens, and in particular the ordinary citizens with a small deposit at the bank, but at the same time with mortgages and other loans taken out from the bank. If during that period of time, the bank is not able to release the deposited funds, that is the deposits of the individual, then it would present problems for meeting everyday life expenses for the depositor, and it will create a crisis for the individual. And perhaps the individual will, may cause psychologically certain problems, such as queuing up to take the funds out from the bank account and therefore causing unnecessarily a bank run. Now, there are jurisdictions around the world in which this had happened, and internationally it is recognized that to bolster the confidence of the ordinary customer in the banking system is important. Otherwise, there may be a contagion effect, that is to say, a rippling out effect because of this. And as Mr. Ng Leung Sing had mentioned, this is not without a cap. There is a limit, and the limit is 500,000 Hong Kong dollars. It is just that we do not net off the loans, but we will pay out the 500,000 regardless of the loan. And a third point I would like to make is that if there is a liquidation on the part of the bank, then the DPB will have the right to recuperate the paid out amount. That is to say, if the depositor has a deposit at the bank, the depositor will have to pay the bank back. So that is at the point of liquidation. So it doesn't mean that the depositor can just run away with money. It will have to pay back the loan to the bank. So on the basis of these 3 points, we believe that we should introduce this, and international regulatory bodies and banking system, financial system have adopted this. And Mr. Ng Leung Sing had asked about the response from various sectors. Yes, in 2014 we have done a public consultation, and we have received 14 submissions, and most of them are very much in support of this proposal, because after all, it speeds up the payout and also the impact on the bank is minimal, as mentioned just now, because the total amount of deposit is calculated. Perhaps the premium from some of the banks would have increased given this, but it will be minimal. But on the other hand, Do you have some data? I'm sorry to intervene, but do you have a stress test as to what is the biggest increase in terms of banks' premium? Perhaps the Hong Kong MA can supplement that if she, my colleague, has the information. We can provide that. Otherwise, no. Ms. Mina Dadvani may have that information. Right, and therefore, the procedures can also be simplified with certain savings because of computer and systemic simplification. Data, do you provide that after the meeting? Well, we have sufficient time today in this meeting. We can, we can do away with the time limit, and we can speak and discuss freely. Mr. Albert,
information about the level of likely increase of premium payable by the banks.
Will it take long?
Is that okay?
Yeah.
Okay. So the Honourable Mr. Ng asked this question about whether premium are likely to go up, because we said it would go up marginally, and he wanted to know whether there was a specific figure. Generally, as the relevant deposits, if calculated on a gross basis, will increase by 10%, that would translate into a roughly 10% increase in premium. But that's not in every case, because in certain cases, there's a lot of banks fall within the 50,000 premium bracket. So if they have a 10% increase, probably their premium would not go up anyway. But for the larger banks, we expect about a 10% increase in premium. And actually, the banks are aware of this, and they're very supportive because they have other benefits that will accrue as a result of going towards a gross payout approach.
最高大概10%，我相信應該接受嘅。
Yes.
何俊賢議員係。
多謝主席。咁呢個條。
Thank you, Mr. Chair. And of course, the depositor and the banks are most affected by this legislation, and I have a banker right next to me, and I of course will ask him as to the banks chasing the loans in the future, whether they're able to do so on the part of the banks. And of course, Mr. Ng is next to me, and I, of course, would put the question to him. Now, especially for the younger people who are taking out mortgages, and if the young person has a small amount of deposit in the bank, and if anything happens, my deposit is withheld, that's no good. Now, what if the bank goes under, completely fails? Then what about the repayment? Let's say if I were the young person, I have taken out a mortgage, I have the contract, do I continue to pay back the bank, which has failed, the loan, the mortgage loan, or do I find another bank to pay back? Or what happens? And maybe I have less than $500,000 with me. There's this young person. And that's the first question. What is the procedure? And second question, what about non-permanent residents of Hong Kong? Would those people be protected similarly as well? Yes. Ms. Mina Dadvani can talk about the procedures in detail, but the main mechanism is as follows. That is, if your loan at the bank exceeds your deposit, then in the liquidation process, you will still have to honor your loan. But for the procedure, perhaps, Ms. Dadvani, and also if you can give us the timing. It was 6 weeks for the calculation, that is the liability and the deposit coming up with a net amount. But now you're paying me back within 7 days. So when do I have to pay back my loan? What is the timing? Now, you're talking about liquidation scenario, as mentioned just now. Now, the the release of deposit to the depositor is contracted from 6 weeks to 7 days. And this, of course, alleviates any urgency on the part of the depositor. As for the liquidation process you talked about, it depends on the case itself, the contract, the court in appointing a liquidator, the process of that will be another process. And what we are dealing with today is the deposit protection and the release of the deposit to the depositor. This is what we're talking about today. From
But I'd like to invite Ms. Dapwani to supplement.
Had experience in Hong Kong, but we know how it's supposed to work. Basically, the Deposit Protection Board in Hong Kong is a pay box. So we pay out in the future on a gross basis. So if you had $500,000 deposit in the bank and you have a debt, a loan of $1 million, we will still pay you $500,000 and we will subrogate to your rights in liquidation and then get back from the proceeds of liquidation. So that's very simple. And we have, there might be a shortfall risk or whatever, but that's our risk. But in terms of whether you default on your loan, that is something that the onus will fall on the liquidator to recover from you. And we have nothing to do with that process of the liquidator calling in the loans. Maybe DOJ might be able to cast some light on, because they probably have a lot of experience in liquidation. I don't know if DOJ can assist here.
And a little bit, if the bank go into liquidation, then the liquidator would be responsible for taking care of the contracts, etc., as against the depositor. So that would fall under the insolvency regime, which is not under our purview right now. If you require any further information, maybe I can get the advice of my colleagues from the Civil Division, and I can give you a written reply with more details, if such is required.
Well, because for the money held back, then under the existing regime, you're not required to pay interest. Now you're going to pay me $500,000 first. And what about interest? How will that be calculated? Because it may be a lengthy process. So what about the interest arising from the $500,000? If the things drag on for 2 years, I need to be very sure that how each penny counts. So the honourable member is concerned about the disbursement of $500,000, and the interest
is that once a depositor gets his deposits back, he doesn't have to pay interest. In fact, he is entitled to interest on that $500,000. So, and if that's in a foreign currency, that will be converted at the quantification date. So there's no question of him paying on his deposit any interest. It's interest-free. In fact, he's entitled to interest.
Chairman, may I also answer one of the questions from Mr. Ho on non-Hong Kong depositors, whether they are protected by the DPS? The answer is yes. Any bank in Hong Kong or any depositor placing deposit with banks in Hong Kong will be protected, whether or not he's a Hong Kong resident. Next, Mr. Sin Chung Kai. Another representative from the administration would like to respond. I want to supplement. Now, I think the member's concern just now was that if the depositor has a mortgage with a bank and the depositor then receives $500,000 from the DPS, the deposit and interest would be paid out to the depositor first, and yet if that depositor has a loan or a mortgage loan, then according to this contract with the bank, he is required to repay the bank. But our understanding is that if the depositor is able to repay in accordance with the mortgage requirements, the liquidators actually welcome these cases because they can sell these cases to other banks in a package. So the depositor will only be required to pay the mortgage repayments according to schedule. Now, for loan contracts, they will be handled separately from the payouts under the DPS. Mr. Stephen Ho, why don't you wait for a second round? I will ask another member to ask questions first. Mr. Sin Chung Kai. Thank you, Chairman. I understand that this review involves technical amendments. That's my understanding. Now, I didn't check the previous records, but the objective of the deposit protection scheme, if I remember correctly, was to protect, say, up to 80% of the deposit. Now, after your review, have you reviewed whether the threshold of $500,000 would actually meet your original objective? Or if there is a departure, will you consider realigning this? Thank you, Chairman. Now, to answer Mr. Sin's question, we believe that the level of protection at present, that is 500,000 Hong Kong dollars per depositor per bank, we believe that this is the appropriate level of protection. We conducted a review in 2011. We increased the amount to $500,000, and that review was related to the level of protection. We believe that the level still applies now because over 90% of depositors would be protected under the scheme. So we believe the level is appropriate. And today's proposed amendments are that under the existing DPS scheme, we believe we can shorten the payout time frame. So in relation to the payout time frame, we have proposed an amendment. We believe the level of protection is appropriate, and this is not the scope or objective of this existing review. Well, since the establishment of the deposit protection scheme in 2006, it has never been triggered. Nevertheless, in 2011, we conducted a review and raised the level of protection. We believe compared to international practices, the level is appropriate. As I said just now, we need to protect the banking system stability first, and this should be our starting point. As for other matters in the past, we made other suggestions to the Council with the support of the Council, including enhancing our standards based on the Basel III requirements. So I believe that this is the appropriate mechanism. Yes, I understand this is not part of your review. In 2011, you conducted a review. I don't know whether your coverage, let's say foreign currencies, term deposits, non-term deposits, I'd like to know more about the coverage, please. Now, in a paper that we issued to the Council earlier, we explained the coverage of the DPS. The protected amount covers the Hong Kong dollar deposits and foreign currencies deposit. For structural deposits, unnamed notes or other financial products such as bonds, warrants, securities, they are not covered. As for ordinary deposits or term deposits within 5 years, be it in Hong Kong dollars, renminbi, or other foreign currencies, these deposits are protected. And we do require banks to set out very clearly and explain very clearly to clients what deposits or financial products are covered or not covered. And we have also made much effort in public education and publicity to explain to the public the coverage of the DPS. There is a high level of awareness, and we believe that the scheme can continue under the existing mechanism. A final question. Your slides don't have page numbers. Well, I think it's slide number 6. The level of premium rates will remain the same. And I understand that the DPS fund size now stands at around $2.8 billion. And I don't think many banks will fail. So do you have a reasonable level in mind? Let's say in reaching certain level, you will reduce the level of premium rates. Now the rate at the level of premium rate is 0.025%, 0.25% of the deposits, protected deposits, and we're standing at 0.16%. So there's still a gap, and at the same time, through the exchange fund, the Hong Kong Monitoring Authority has this regular safety net, if necessary, that if necessary can be utilized, and they're amounting to $120 billion. So we believe the existing level is adequate. Next, Mr. Andrew Leung. Chairman, I support this bill. It streamlines the process and it gives greater protection to depositors. However, in the event of the DPS being triggered, I think the process is simple. But according to Mr. Stephen Ho, what happens after the payout is complex. It's not covered by this bill. Now, for example, if a young person takes out a mortgage for the property with a bank, according to the administration, the liabilities will be sold off in a package. I think the government should also look into what liquidators should do in such an event to sell off the assets or liabilities, because we have SMEs, and if they're required to repay immediately, they may not be able to take out loans from other banks immediately, and this will affect the whole monitoring system. So I think the administration, especially the FSTB, should consider this and formulate a policy to tackle the issue, because people will panic. Of course, I will be given compensation, but if I'm also required to repay the mortgage at the same time, then I may need to take out another loan from another bank, and originally I may enjoy a fixed interest rate of about 1%, but the interest rate may be shot up to 9% all of a sudden. So I think this bill itself is simple, but I think the administration should consider other peripheral issues. Well, of course, liquidation is under another regime. But we should not adopt a fragmented approach. The administration should consider, in the event of a crisis, what the liquidator should do, or how the Hong Kong Monitoring Authority could help ordinary members of the public. and it will be very unfair to small-sized banks. So I think that our monitoring system is stable, but you need to, plug all loopholes. So just to give you an idea.
Thank you very much, Mr. Leung, for your suggestion. It is a very good suggestion and reminder. As Mr. Leung had mentioned just now, the legislation is of some urgency. That is to say, where the depositors will not be able to get the deposit back from the bank, and in particular, if there's a situation if after netting the depositor is not to get anything back from the bank and as his deposit, then he will have dire consequences in terms of meeting his everyday needs. So that is the approach that we are coming from with the amendment of this bill. And but we will look at the procedure to see how the banking system will handle this, and we will look into it as suggested by Mr. Leung just now. Now, from the Hong Kong MA, the observation is that a lot of people actually separate the banks, that is, deposit from their loan or the banks from which they take out a loan. There are lots of such cases. So not necessarily the depositor will take out a loan from the same bank. We will look at the situation as Mr. Leung had mentioned just now. Yes, because if there are problems with the banks, even if the depositor has a number of banking relationship with different banks, it would be very difficult for that young person, as mentioned by Mr. Ho just now, to function, because the liquidator will not release the loan very early. It will take a long time before the loan is released for the young person to take out another mortgage with another bank. I mean, we have to settle the minds of our young people as well. Yes, we will look into it. And anybody else? Points of supplement. Yes, second round. Yes, you would not face this problem before because, with the netting, the depositor is left with nothing after netting the loan. But on the other hand, for the mortgager, the young mortgager having to go to another bank to take out a mortgage, is problematic. So before the amendment of the law and after, you should list out the different impacts, those that you can think of. List out the impact in different scenarios and let us have a clear view so that we know what the consequence of the law is after amendment. Perhaps Mr. Ho does have a mortgage. Well, it's exactly because I have no assets, very little assets to speak of, and all my deposits, very little of it, are all banked with the gentleman next to me, his bank. So I think for the young people in particular, the impact will be big. Mr. Chair, under this bill, if there is any effect or consequence, it would be positive effect or consequence. Where there is insolvency on the part of the bank, then the depositor will be able to recuperate his deposit faster. So that is a good thing. And also the procedure would have been streamlined because the DPS would have stepped in and there will be a liquidator. Well, I understand that this is the right approach. I agree to that. But sitting in the office, sometimes we do not know what's really happening in the real world where the real people are affected. let's say, if you net off, then all I have to do, and I have zero money left, then all I have to do is to work harder and make more money. But you're talking about a lot of headaches with this new amendment. There are a lot of technical issues the person will have to think about. Yes, I know the general effect is good, but I hope to minimize non-monetary effects, bad effects as well, if you understand. Yes. Mr. Chair, I think my colleague Mr. Ho is approaching it from a very practical point of view. And it can happen. And I think indeed, in considering the amendment, yes, there's been a lot of publicity in education for the deposit protection, but on the other hand, I think we have to consider the cases as outlined by Mr. Ho. That is to say, where the depositor has loans with the same bank, but at the same time, the person is given back the protected deposit, and it elicits for certain queries, such as mentioned by Mr. Ho. It is very practical. So in your future publicity, would you please include this as an explanation as well, and perhaps use certain scenarios or venues or fora to educate the people about this, whether this will become even more problematic in the future given this new amendment. Of course, within insolvency of a bank, that itself is already problematic. Hong Kong, some years ago this had happened, but I certainly do not want to see it repeated. But if indeed it should happen, what would bring about the full protection of the depositor, including these depositors with loans? Not that the depositors do not want to repay the loans, but if it drags on the liquidation process and there are these problems, headaches that come with the loans. Now, there are questions there. So if you can educate the public about that as well in your future efforts of publicity. Now, if a bank will have to resort to the DPS in order to repay the deposits, and also the relevant organizations involved in that insolvency case would act quickly, I'm sure. And at the same time, the regulatory body would have also intervened. The Hong Kong government would have intervened by then. And so do let the public know that with this amendment, it will not be problematic or cumbersome for the depositors, but rather it will be a reasonable, I cannot say simple, but at least within a reasonable time, the matters will be resolved. So I think this is a very practical issue we have to address. Any other members, please? The Deputy Secretary, you have something to say? Mr. Chair, we fully agree with Mr. Ng. At the passage of this amended bill, we will step up with publicity, the entire mechanism for payout, and also how it affects the depositors, what is the way of handling the whole situation. Yes, we will step up with publicity. Needless to say. And over the many years, yes, indeed, publicity had been done very well. And it's been well received by the public of Hong Kong. With the new scheme, I'm sure good and understandable publicity will be designed so as to educate the people of Hong Kong, and in particular the young people, as to how this will benefit them, the procedures they're in, and when they can get their deposit back, so that they understand this will not complicate things, but rather it is it has the intention of simplifying things. We will be talking to the DPS for the publicity of it. I'm sure this is all good for the community. Do we need a public deputation? Well, written submission would be fine, I think, Mr. Chair. Only if necessary do we call a deposition. Yes, let's be practical. I agree, Mr. Chair. We know about the queues that we have at the LegCo with the other bills. It will take time for the deputations to be called. And also, we do not see any major objections. And also, there's been communication with the banking sector as well. And they are in support. Unless the government has received new submissions or dissenting views, otherwise I don't think we need a public deputation. But to do some work in collecting written submissions for view of this panel, I think that would be appropriate. All right, the Secretary. Yes, I agree. After the consultation, actually we have collected all views, and in May of this year, we have also published a conclusion document to the consultation. Now, the opinions are mostly in support and mostly technical in nature, and we have appropriately absorbed and taken on board the views of the sectors, including the banking sector, and made appropriate reflections in the amended bill. So I don't think we need to further obtain more written submissions. And also in the drafting of the amended bill, we have also been talking to the banking sector, and they feel that this is workable. So we have done that work already. And I don't think there is any controversy to speak of. There are no particular dissenting views received as well. Well, we have half an hour to the closure of this meeting, which is 10:30. Should we go to clause by clause? Yes, Mr. Liu. Members, I believe you have the blue bill with you. And the Secretariat had also come up with a clause-by-clause document, and it also talks about each and every amendment in the bill. Perhaps we can go through that document and see whether members have any questions. First of all, the long title of the bill. This is the Deposit Protection Scheme Amendment Bill. As mentioned, this will be in will adopt a gross payout approach to determine the amount of compensation payable to the depositor and to recover the amount of compensation paid, and to revise the definition of quantification date to enable the board to notify affected depositors by electronic means, and to make consequential and minor technical amendments. And the first clause is a short title. The second is sections 3 to 11 amended as set out. Clause 3 is about Section 25 substituted. This is about the quantification date, and according to Section 22 bracket 1, the date therein is a quantification date. And if we go to Section 22(1), as mentioned just now in the PowerPoint, the court giving out the liquidation order or the Hong Kong MA notification date, any one of those, whichever is the earlier date, as mentioned in the paper, is to be the date. And the next one is that is Section 4, is Clause 4 is Section 27 amended to repeal subsection 3, that is, and also to, in subsections bracket 1 and bracket 2, to have the specified amount in relation to compensation to which a person is entitled from the fund, meaning the aggregate of the total amount of protected deposits to which the person is entitled as at the quantification date, and the interest accrued on that amount calculated up to the and including the quantification date.
And then for Section 27, 4A, under Clause 4, we're going to repeal the words "all liabilities are not," because we're taking the gross payout approach. So we have the consequential amendments to delete the arrangement applicable to a net payout approach. This is in relation to amendments to Section 27. Please go on. Thank you, Chairman. Clause 5 amends Section 32. We're going to empower the Hong Kong DPS Board to give electronic notices. And we're going to add after Section 32(7) that 7 capital A, subject to subsection 7 capital B, the Board may comply with subsection 7A by issuing the notice to the depositor in hard copy form or in electronic form. 7 capital B. The Board must have regard to the matters the Board considers relevant in the circumstances in deciding whether to issue to the depositor a notice in hard copy form or in electronic form, and B, take reasonable steps to satisfy itself that the notice in electronic form will come to the attention of the depositor. By taking reasonable steps, we mean that regard should be given to the way of electronic communication and the habit of the depositor's communication with the bank, whether the depositor is used to receiving electronic messages from the bank, or whether the electronic notices are safe, and all these steps will be taken so that the Board is satisfied that the scheme member can send electronic notices to depositors. And we believe that after the bill is passed, the relevant procedures will be laid out and banks will be approached for the collection of information in this regard for enforcing the provision. As for hard copy form and electronic form, it's in 5(3). In hard copy form means in a paper form or similar form capable of being read. In electronic form means in a form of an electronic record, being a record generated in digital form by an information system that can be transmitted and stored. And with drawn reference to the Companies Ordinance and the Electronic Transactions Ordinance in drafting the definitions for electronic form and hard copy form. Legal advisor has a point of inquiry. Now, in the definition of in hard copy form, I see the expression similar form capable of being read. Can you please explain what is meant by similar form? Thank you, Chairman. I understand that the legal advisor wrote to us yesterday evening on this point, and regarding the definition of in hard copy form, we actually drew reference from Section 372 of the Companies Ordinance. So in paper form, that's very clear. In similar form capable of being read, on this we consider that in the future the hard copy may not be in a paper form. It may be in a form that is capable of being read. So we'd like to take a broader approach in our drafting to play safe. But basically, when we mention in hard copy form, basically mean in a paper form. Legal advisor. Yes, as you mentioned yesterday, I issued a letter to you and asked this question. Electronic record or in electronic form. Again, in this definition, it says that the information can be transmitted or stored in an information system or other medium. Can you explain what other medium means? Now, in relation to this definition, we drew reference from the definition of electronic record in the Electronic Transactions Ordinance for consistency. As for an information system or other medium, again, we have taken the broader drafting approach so as to cover any new technology, so that other medium other than the existing information system can also be used. We're still thinking about an information system, but we'd like to play safe, and we're using the catch-all approach in our drafting. And we also have other similar provisions for reference, such as the definition of an electronic record under the Electronic Transactions Ordinance. Another question on the definition of in electronic form. I have a suggestion. In the Chinese text, it says that it being a record generated in digital form by an information system which can be transmitted and stored in an information system, which can be transmitted within an IS or from one IS to another. So I think for greater clarity, you should state that it is transmitted from one information system to another. That's what it should mean in Chinese. I believe I've replied to the I think the drafting is clear enough in conveying the message, and I'll go back to and talk to the Law Drafting Division about this. Now, let me supplement. We have actually drawn reference to similar provisions in other ordinances. Well, this is actually a reference to section 2 of Cap 553, and in the Chinese text, capable of being transmitted within an information system. The Chinese word meaning within actually conveys the meaning. We believe that it will be cumbersome to add the word transmitted within one information system in the Chinese text, because the whole sentence would read transmitted within one information system or from one information system to another. It will be less accessible to readers. We believe that I believe the existing drafting will be easier for readers to understand that we're referring to transmission within an information system. Chairman, we also believe that the existing drafting can reflect the policy objective. We don't believe an amendment is appropriate. Anything to respond? No? Next clause, please. Clauses 6 and 7 are consequential amendments. In relation to amendments to citations, because we have amended the section 27, so section 35 and 37 will be amended correspondingly. Clause 8 refers to an amendment to section 38, subrogation. In section 38(1), we will make clear that under the gross payout approach, how the board will, by way of subrogation, obtain all the rights and remedies of the depositor in relation to the deposits with the scheme member. And the scope of subrogation is the aggregate amount. And the board will have priority over the rights and remedies of the depositor in relation to those deposits, and the depositor, the rights and remedies of any person who is subrogated, whether or not before the board's subrogation, to the rights and remedies mentioned in subparagraph 1. So the board will subrogate or will be subrogated to all the rights and remedies of the depositor. As for Section 38(1)(b), the expression will be repealed in relation to the net amount, because we will be taking the gross payout approach. And in the aggregate amount, we're not going to make any reference to the setting off requirement. And after Section 38(1), we're going to add one capital A, B, and C. That is whether or not the bank has wound up, the setting off requirement will be carried out in accordance with capital 1B and C. 1A, subsections 1B and C apply in relation to recovery by the board or for payment of compensation made to the depositor of a scheme member from the fund. And in relation to the rights and remedies of the depositor to which the board is subrogated up to the aggregate amount, any law relating to set-off, including Section 35 of the Bankruptcy Ordinance or that section as applied under Section 264 of the Companies Winding Up and Miscellaneous Provisions Ordinance, Cap 32, or any right and obligation with regard to set-off that has the effect of set-off. That means for subsection 1B, it doesn't the following. I mean, what's said about do not apply to the rights and remedies of the depositor being subrogated by the board. Now, in relation to Section 38, the section applies to the deposit, whether or not it is a protected deposit. And we're going to repeal subsection 7. And we are going to make clear the aggregate amount, meaning that it should cover that amount and any interest accrued on that amount calculated in accordance with subsection 5. That's the amendment to Section 38. Any comment? Yes? I have a question on Section 38(1)(a). It will be amended. Now, in English, it's notwithstanding any rule of law. That's the original text. The new text reads, despite any rule of law. I want to know what rule of law the administration anticipates that will be relevant. Who will take the question, please? Perhaps I'll respond, and perhaps Mina could also respond to that. Now, in the new 1C, the setting off requirement under the existing law, such as the Section 35 of the Bankruptcy Ordinance, Cap 6, or the Section 264 of the Companies Winding Up and Miscellaneous Provisions Ordinance, or the Common Law, or the Equity Law, the setting off requirements may allow the setting off of the deposits with the bank against the liabilities owed to the bank. So we make clear that despite any law relating to rule of law, the board is subrogated to the extent of the aggregate amount to all the rights and remedies of the depositor, so that for the aggregate amount, the board is subrogated to all the rights and remedies of the depositor. And basically, I think 1C is referring to the setting off requirement. I don't know if Mina would like to supplement as well. Chairman, I understand that in relation to subrogation, and its importance under the deposit protection scheme. But my question is this. In relation to the drafting of this statute, whether this is the most appropriate approach, because in English, despite any rule of law, seems to suggest that this bill overrides everything else. It seems that it transcends all other rules and regulations. So this is quite peculiar. A less peculiar way of drafting may be this. The board has absolute power of abrogation. It has the overriding power of subrogation. I don't know whether this is a better way to express this than putting it in the expression like despite any rule of law. Because any rule of law may not cover case laws under the equity law. Because in English, the expression despite any rule of law, I think on the face of it, concept-wise, I don't think this is the best way to draft it. Of course, we have law drafting professionals, and I'm a layman in the drafting of bills. But as a legal practitioner, I just want to know whether this is the best option. Perhaps I can invite the professional, the expert, Bonita, to answer your question.
Thank you for your question. We basically want to retain the original drafting, the original wording in the law. As for despite any rule of law wording, we have changed the notwithstanding to despite any rule of law, and the impact is the import is the same. So it is for the Chinese version as well. And 任何法律規則 is the Chinese version for despite any rule of law. Given the suggestion, we will look into whether there is any room for improvements. Perhaps we can come back with a written reply to your point. Thank you. Mr. Chair, well, being wrong a few times doesn't make it right. Well, perhaps it is not. I'm not saying that this is erroneous, but if indeed there is room for improvement, then let us take this opportunity to make that improvement. As for the concept, I accept the concept. That is, the DPB is given a subrogation right, and it has a priority in assuming that right. That I accept. But the drafting, I find it worthy of further study. If there is a written response back to the panel, I would welcome it. Mr. Chair, so in terms of policy, there is no controversy that it is absolute and it is a priority for the subrogation right. We note that. Now, going forward, we have certain changes. For example, and loans. We will delete and loans because there will not be any loans. And then we go on to some clause 10 there, section 57. We add that and also for Section 57, transitional provisions in relation to Deposit Protection Scheme Amendment Ordinance 2015. That is to say, where the commencement date is, because we are already doing the calculations, that is in October 2015, the deposit amount is used as the base for calculation. And for 2016 deposits, we will also use the original arrangement to handle the matter. So this is for transitional arrangements between 2015 and 16. And also, we have made some changes to the definition. And this is because in the future there will be a gross payout, and in the contribution it will also be based on a gross payout basis, so that we calculate the protected amount for payout and then to use that as a calculation for the premium rate to be contributed by the banks. And therefore, in subsection 4, we have also deleted the mention of loans so that the DPB, when collecting the contribution or rates from the banks, will be able to base that on the gross amount. That is the introduction for clause by clause. Are there questions from members, please? No? Well, I would like to ask, if we do receive any submissions from the public, we will circulate to members and we close the discussion on this bill now. I would like to ask the administration, when will there be the second reading? As soon as possible. Mr. Chair, yes, we will come back with a written reply on the issues discussed just now, and then we'll proceed as soon as possible.